So what we're going to talk about here today is a lot of information, a lot of things that we've learned over the course of many years, and in particular related to jury research. So everything that we've been talking about here today are things that we've collected data on, findings that we found based on research that we've done. So to give you just a little bit of background too, so we're going to talk about a bunch of different stuff. We're going to talk about storytelling, what makes up a good story, what jurors are looking for, predispositions that they have, how to tell your story from a graphical standpoint, if it's appropriate, the different types of things that are out there and available. To give you some background, we saw about 10,000 jurors last year alone, just in focus groups and mock trials, not including profiling studies, not including our trial studies that we did. So we're very, very active. We have a lot of data. And if there's any questions that you have throughout this, you can just stop me and just ask a question. But we are an end-to-end provider. So one of the things that's unique about Magna and what we offer is we offer a solution all the way through the trial. And the thought process there is because this stuff is so integrated in with your themes and with your case and things like that, that it streamlines the process. So we are able to take you from all the way from discovery, but from the consulting of what we're talking about is under one roof, we're able to provide all these services. So graphics, to trial presentation services, to shadow juries, to all different types of things. Now I'm going to go through these in detail because some of them you might know and other ones are kind of newer concepts in jury research that are available, including online focus groups and things like that, that are a fraction of the price. So one of the major things is that jury research can be cost prohibitive. There's no doubt about it. You have to have the right case for it. We realize that. I hear that a lot from clients. What's the right price point? Things like that. So we're going to talk a little bit about that too. But I'm going to use this slide to kind of talk you through a few of the concepts here, and then we're going to go into more detail about that. So on the jury research side, what we're really going to be talking about today and a lot is focus groups, mock trials, and online jury research. Okay, all of those are in-person studies. That's where we actually bring in people. So if your case is here in the Court of Common Pleas, you're actually going to bring in jurors. You're going to match the panel, and you're going to bring them in, and you're going to run live in-person studies, just like kind of everyone is sitting here. A lot of times we run them here, and the jurors would be sitting where you guys are, and we're giving presentations. The lawyers are giving presentations. That's all in person. Okay. I get asked the question, we get asked all the time, who's a good or bad juror for me? Right away, that's the first thing you want to know. Who's bad for me more than who's good for me, right? In mock trials and focus groups, chances are you're not going to get that kind of information, not on a demographic. And people ask that all the time, so that's where we want to fit things into. Male, female, race, socioeconomic status, whatever it might be. It's easier that way to do that. But a lot of times it's not. It's about the narrative of the person and the narrative of the case. So the reason why I'm giving you that information is because the next step up, what becomes statistically significant is a profiling study. And everyone's probably heard those profiling studies. One of the most famous ones is in the Michael Jackson case, the one where he was on trial for molestation, that case. And the reason why what you do with profiling studies is where I said it's not statistically significant. In a focus group, we're going to bring in, maybe there's 50 people here right now. That's not enough. Where you bring in 500, 600, 1,000 people for a profiling study, that's all done, now we do them over the internet. So they're like e-surveys. They'll see like a 20-minute video, both parties' positions in the case, and then they answer a battery of tests, and then those numbers are correlated, and that's where you get into who's a good or bad juror. So with the Michael Jackson trial, and that's like one of the most famous ones, was they prepared a profiling study for the Michael Jackson trial, and 85% of the jurors in that venue, just on the mere onset of his name, he mentioned his name, 85% of them thought he was guilty. They were predisposed to that, based on media coverage and everything else and whatever. So here's the rub, though. They go into the trial, they start going through voir dire, and they start asking the question. Now, they have a profiling study that's statistically significant. That's been provided by a jury research expert, right? That's an expert just like any other that can testify. And no one's raising their hand. They can all be fair. They can all give them an even, so will you be fair to Mr. Jackson? Oh, yes. 85%, remember, of these people, and this wasn't a small study, this was thousands and thousands and thousands of people who they had. So what happened was, is somebody like me, Lord Kelly, had to go in, testify, talk about the study, and they had to move to private voir dire, and right away, the minute they had them into individualized private voir dire, everybody started telling the truth. So it's just a way that you can use profiling studies, but that's what they're used for, and they had a profile, is this type of person, a person with a certain type of background. All right, so, but those are done over the internet. Or they can be done over the phone. Then you have different things like witness communication training. We'll talk about that. Witnesses that teach them how to communicate properly. That whole thing, you'll take them out to the woodshed and you're not going to come back until they know what they're supposed to say, kind of thing. Jury selection and voir dire, we're going to talk about technology wrapped around that, some different techniques and things like that. And shadow juries, has anyone ever heard of a shadow jury? Heard of them? Okay, shadow juries are pretty unique. What I just talked about with online jury research or mock trials or whatever, where we bring people in, a shadow jury is where we actually run a focus group or mock trial type study in the actual courtroom. So if these 8 or 9 individuals over here are my jury, I'm going to pick a person that closely represents each of them, and they're going to sit in that courtroom every single day, and they're going to watch the trial, and then we're going to debrief them every single day, and then we're going to apply that strategy day over day. They're very, very effective. They're extremely predictive. I haven't had one that we've done that hasn't lined up with the verdict, the actual verdict. They're very predictive, okay? They also can be very expensive, depending upon, we just got done doing a 7.5-month long trial with a 7.5-month long trial. So they're really effective though for the openings. We're going to talk about all this stuff. I'm going to break it down, but I just want to give you some background before we launch into to some of the different concepts. Okay, so what are the purposes of jury research in general? In general, theme development. We're going to talk a lot about stories. That's what's persuasive. That's what persuades people. That's how we communicate. We started telling stories around a fire a long time ago. You'll see all the different stories in caves and things like that where people draw pictures. That's the way that we communicate. That's what's persuasive. You see that all the time with jurors. The same facts, the same information rolled out in a package that isn't persuasive or isn't appealing to a juror can have no effect. That same exact set of evidence, facts, documents, everything packaged up the right way, sequenced in the right order, has an overwhelming effect. It can be very persuasive. Some documents, some things that you think are very, very important and that we might think are important, just aren't, and we can keep trying. And in a case that I just got done with, we had 10 days of jury research. We had many, many days at trial. The document just wasn't important, and it was the biggest part of what we were trying to build the case around, and it just turned out that that document was not really important. The problem was the whole reason why the case was filed was around that document, so there was a little bit of a political issue there, but at the end of the day, it wasn't important, it had to be about something else. But that's what the early phases are. It's not just for trial, though. There's things that are available, and I'm going to talk more about the different phases of where you can conduct jury research. But what you're looking for is different things. How much is the case worth, right? At the end of the day, how are they evaluating? What are the damage ranges? How do they approach issues? Are they really upset? What are the triggers? What's important to them? What's not important to them? Those types of issues. So theme development, story development. What evidence is important? Who's going to tell that story for you? Do you have key witnesses that you have that really, at the end of the day, what's important to the jurors has to come from 1 or 2 people. And then you test those 2 people and you find out, wow, they really didn't like them so much. So we have to go back and figure out it has to come from somebody else. We do that quite often. That's what she uses for. And those types of things. How do they feel about, you know, the lawyers, you guys? You know, is there something that you're doing that maybe they don't like, something we can change, all right? So here's something we're talking about change. You can't change the jurors. You will not change them at all during the trial. What they come to the table with, their predispositions, their biases, they're not going to change. You're not going to convince them of something different, like CEOs are trustworthy. There's too much out there. So, you know, if you have a case where you're going to bring in your CEO or management level person, and that's the crux, chances are you might want to divert it to somebody else. And a lot of times we are lower level people. Maybe there's somebody else. Maybe it's an expert. Although that's starting to change a little bit, and I'll talk more about that. That's changed since WorldCom and around that kind of a thing. We're starting to see in the last 8 months a little bit of a difference there, but in general. So there's this concept of lock. Does anyone remember? Anyone take any psychology? A little bit? Long time ago, tabula rasa. Probably Pavlov and this guy, they were the two that you'll remember. Tabula rasa, it's a blank slate, okay? So one of the things that's important for us is that the jurors come in as a blank slate. They don't know why they're coming, okay? And if you guys, and I want to talk about things that you can do on your own without hiring a jury consultant also. You can run jury research at your firms and things like that on cases, or how you can test things in groups of people just at your offices. We'll talk a little bit about that because you're not always going to hire a jury consultant, which roundtabling your cases is probably a good idea at some level. But it's really important that they don't, before they hear any stimulus, before they know why they're coming. They could be showing up for the Pepsi challenge across the street or across the hall, really, or they could be coming in for the tractor trailer accident where there were 12 fatalities, and that might seem a little tough for the jurors, but they're all pre-screened ahead of time so that they don't know anybody. They go through we go through a rigorous process to recruit them. We'll talk more about that too. But the most important thing is we want to ask a battery of questions. And this is how we get their biases. So we can't tell them that we're here for something like a PI case or whatever it might be, and then start asking them questions about issues. There's some general types of questions, and then there's things that get very specific into whatever types of cases. If it's a products liability case, does a product have to be 100% safe in order to go to market, right? Can a dangerous product be used safely? There are people that just believe it cannot. Like, there's just no way. There shouldn't be dangerous products in the market, or it has to be 100% safe. Those types of people, those are voir dire questions. Those are questions that you can use during voir dire, obviously, but they're here also. We get to see how they play and how they evaluate. Is that person good or bad for your case? Those types of things. So this is an important question. So have you had a significant loss in the past 3 years? And that could be anything. We try not to define it for jurors. If jurors have had a significant loss, whatever they believe to be a significant loss. So it could be a bankruptcy, a financial hardship, whatever it might be, loss of a close family, friend, that type of thing. If they answer yes, 85% of the time they're going to be plaintiff-oriented in a personal injury case, okay? So, but it has to be within 3 years. If it goes outside of 3 years, it falls drastically off. So people don't take enough personal responsibility these days for their own actions, right? People overwhelmingly will answer this question. When we answer yes or no, it's like there might be one person that does it. Here we give them a little bit of an out, and here we've got 2 people in this. But we're asking questions. Sometimes we ask them on a sliding scale. Sometimes we ask them where they're more absolute. But what we're trying to do with all these questions, and you'll see, is I talked before where we can't really correlate to a particular demographic, but we can to a particular bias or to a particular belief. A lot of times we'll find a correlation. So somebody who owns a home, right, and has children is defense-oriented or plaintiff-oriented in this particular case. So there could be a couple of characteristics, and that's what we're looking for. We're looking for a combination of things. So, and we can correlate those. This one is probably one that you're probably interested in, right? A little bit. So this is actually here at Court of Common Pleas. So you'll be happy to know that jurors here overwhelmingly do not believe that jury awards are too large. It's probably not a surprise, right, for Philly. So people who come here, who are not from here, who, let's say on the defense side, that start to see, they know Philly's bad, and then when we ask this question, they realize just for them at least, how it's difficult, or it could be difficult for them. But these types of questions, these are the ones that we're asking. So, corporations today care more about profits than people's safety. This is also from Philadelphia. So these things are interesting to know, especially here. If you had a products case, in a products case, I mean, what is it? Your profits over safety, right? They care more about money. That's one of the major themes that you hear all the time. In different venues, that resonates differently. It also plays the role with what did the plaintiff do in that case, because I'm going to talk about that too, about the role of the plaintiff and how that's important, how that can be moved drastically to where jurors will put a lot of personal responsibility on the plaintiff, especially in child death cases. The parent that's responsible for that child, especially in a drowning case, they're going to look square at the parent that was there. And they're going to be laser focused, especially women. And I'm not to try to, but there is a difference, and I see it all the time. In drowning cases that involve, a parent or a guardian, the men will be much easier on what happened or to the mother, and the mothers will not. So that depends. You're not going to move every mother off of your case. So that's not what I'm suggesting. So the jurors show up, you can get every woman off. You need an all-male jury. Probably not going to happen. You're probably going to have people who have kids on there too. But those are just some of the observations. So predispositions, those equal damages too. I'm going to talk about some fear-based decision making for a second, and then we're going to start to move into something that's very interesting, because there's a lot of new information that's coming out related to neuroscience and brain chemistry, and how stories affect the brain chemistry, and how you can couple with jurors and things like that, with eye contact, with stories that are compelling to them, and how you can actually alter their brain chemistry to the point where when they start hearing, just like Kelly will talk more about it, but when you talk about a tennis player, there's memory there. There's muscle memory, and there's also memory within the brain that starts to elicit a response on the mere onset of something like that. So here's something. So for car accident cases, right? And we see this all across the country, by the way. This is one of the most unique questions that we ask. In car accident cases, it doesn't matter what venue you're in, these percentages they mirror each other almost across the entire United States. It's really very unique. So is driving inherently dangerous? 85% of people will say yes, okay? So, but I can guarantee that, and we've even asked the people, you don't have a lot of anxiety, even though you believe it's dangerous. Why? This gets into your belief system, to jurors' belief systems. So if I go out every single day and I feel like you guys, I have my self-preservation is on the forefront of my mind, I trust that all of you are going to follow the laws. You've been trained to drive just like I have. Truck drivers are even on a higher level because they have a CDL, so the commercial drivers are even better drivers than me. I'm going to stop. I know there was a chuckle when I said so we'll talk about trucking too, because that's what we're going to go do. So you're going to stop at a red light. You're going to stop at a stop sign. I expect you to. I expect that I will. Those types of things. So there's a low level of anxiety. Taking out the 15% that are afraid to drive, that have some sort of phobia about driving or whatever it might be. All right? So same thing, it's pretty similar when you ask about tractor trailer drivers, right? So yes, they're dangerous, okay? When you ask if they're reckless, they mirror, they flip. And what's interesting about that is because that builds up your belief system, right? So you want to feel like you have a sense of control. I just went through it. That when I drive, people are going to do what they're supposed to do. So you're not going to believe that someone's going to be reckless because why? Your anxiety, everything else, right? You're going to drive around thinking that the next tractor trailer driver is going to run you over, or the next driver. It goes the same for drivers are reckless. Automobile drivers are reckless. It's basically the same thing. Why? So it's kind of an interesting thing. I'm bouncing past. So there's all these different concepts about evolution. There's some of this reptile stuff. I'm sure people have heard about all that too. But it gets down to core beliefs. So one of the key things is for jurors is how will this affect me? We all have a great need to feel safe. And it's very, very important. So when jurors are evaluating cases, they're thinking about this. They're thinking about these concepts. They're thinking about their belief system. And they've got to rectify the belief system. Either they've got to set it straight. So if they are reckless, they got to say, well, we got to take care of this, and that's where we'll talk about punitive damages, things like that. Or they'll use the personal responsibility argument that says, well, that would never happen to me because I would never drive through a construction zone at 80 miles per hour like a lunatic, and then this guy comes in here and they want money, you know, those types of things. But so how does it affect me? They want to feel safe. So it's a mechanism, and it helps us and it helps all of us to cope with very stressful situations, or when evaluating stressful situations and things like that. And things that are part of our everyday lives. Car accident cases are like that for jurors when there's something very horrific, you know, not just like a fender bender or something like that. And especially when you get into commercial cases where you have truck drivers and things like that, no brakes, or brakes are out of adjustment. The guy's been driving for X amount of hours. His log now with all of the GPS systems that are in the trucks, you know, you can get virtually everything. All the data can be downloaded. You can see exactly what the person was doing. I mean, we just had a case. I just had a case that I did where you literally we correlated cell phone records with the GPS computer in there to show exactly that the guy was on the phone when he ran over the pedestrian, and where he said he wasn't in the deposition. But we're actually able to take all the technology, put it together, and now he's on the cell phone. That's another thing. Cell phones and texting. Everybody does it. Everybody probably here has texted, and you'll say maybe you don't, but you've texted or you looked at your phone and maybe you're trying really hard to put it in the glove box and act like it's not there. But most people, but when they hear that somebody did it and it's part, they were on your phone during the accident, people go crazy. They go crazy. So it's an interesting concept. But everybody kind of, when you get them alone, you say, do you do that? Yeah, but I stopped doing it, or I don't do it that much, or this is why you can't do it, or you know, anything like that. So it's just an interesting thing. We're going to talk more about that. What was that?
So I can do it because I'm good
Yeah.
at it, but they're not.
But they're not. Like the same reason why that 80 miles per hour through a construction zone. Just this morning, I was running through there, sticking my middle finger out the window at everybody, and then I got to the courthouse, and all of a sudden, oh, whoa, you can't do that. That's not okay. You know, they take a totally different position, right? And that's part of it. It's okay for me. Well, I didn't really mean it, or it was okay. But then when somebody else does it, you know, it's a whole different process. So this is just some of the things, as we start getting into the story, we're going to talk more about the story. So what is the case about? How do I organize the information? And it's a lot of information for them. You know, and there's a hierarchy that develops, and there is anxiety along with serving as a juror. People do not want to walk, in the morning they don't walk out there and say, I hope today everyone thinks I'm really stupid and I want to be disliked. Those are not two goals that anyone's going to have. Jurors don't have them either. So if they're not educated properly, if you guys don't give them the arguments for your side, that bolsters your side, so when they're met with an adversarial juror, that they can then, you know, thwart them off. They can say, no, here, that's why this is it. After a while, and in a very quick while, they will start to regress. They'll start to, you know, to move back in their seat. And they will just sort of go with the flow. So they need to be armed with the arguments that support your case, so when they're met with an adversarial juror, that they're not an unpopular position. You know, if a position can get, so for example, conscious pain and suffering of a child, let's just use that. It's not a very popular position, right, to talk, or it's not a popular thing to talk about, it's not comfortable for jurors. But if that position early on by the defense can get legs to it, then it can pick up steam, and it can go somewhere. If it doesn't, and it's an unpopular position, you should see even the people that would argue vehemently and don't even believe it will start to kind of fall back. In other instances where people don't really understand medical malpractice cases and things like that, I mean, they're going to sit there and try to argue, you know, somebody with a high school education, let's just say, is going to start to argue about that with somebody who somebody else. No, they're not. They're going to revert back to a story, something that's familiar to them. And you have to make sure that you fill in all the blanks for them. Because if you don't fill in the blanks of the story, they're going to fill them in for you, and chances are they're going to be wrong. They're going to be not in the way that you want them to. So, and at the end of the day, who do I believe, motive, things like that. So,
defendant, are you the plaintiff?
So let me talk a little bit about what jurors want. And we're going to start showing you videos from different jurors and things like that. But this just gives you an idea after I just talked about that. So we come in, We do these presentations, they're kind of clopening style presentations, the lawyers do them, you guys. For those of you who haven't been involved in the focus group before, they're much like a closing, but we call them clopenings because they're closing and openings put together. And you'll present both sides of the case. Then the jurors will be given a verdict form, they're read a jury instruction, they go in, they start deliberating. And then that's what these videos are for. These videos are from, and you'll see here, this is what the
defendant or either the plaintiff state what it is you believe. He was a partner, he was a this, put the issues, tell me what you're going to tell me.
Okay.
Then you tell me with all of your documents. And then in your summation, tell me what you told me.
Okay.
And I never got, what are you telling me? I had to just float around and follow. You're so vague in getting there. Tell them what you want to tell them.
So it sounds like,
So it sounds like we got it all wrong. But the thing is that, you know, you get this feedback. Again, you know, these focus groups, the good thing is people get really frustrated at them. The clients get frustrated at them. I always tell them it's fake. So whether you don't get enough money or you get hit for too much money, it's a good thing you got it here because it's not real and you can fix it or you can do something about it. But what's important, she's military background, very smart, she's got a PhD. So she's not somebody who you can just easily dismiss as saying, well, she's just not smart. So that's why, you know, because that's one of the other things is that people here are not that smart, they just can't get it or something like that. But she certainly doesn't fall in that mode, and most jurors don't. But what she's talking about is you know, show me with your documents. So you got to tell them what your story's about. That's why your opening is so important, and we're going to talk about how important the opening is. Because once they get a filter in place, once they decide that this is what the case is about, they are going to remember information that fits into that system, into that context, and they will not remember stuff that is opposed to their position. I mean, when you go back and you'll actually look at studies and they'll say, they don't even remember they heard something that didn't fit into the story that they're telling, the narrative that they've built up, that construct. They'll totally act like the information, even though it was there. So it's very, very important. And it's not just one time. We just talked about that a little bit earlier, where you'll have jurors, you know, they have to be armed with the information so that they feel empowered to argue their positions. So you can't just tell them one time and then move on. You can't tell them once in the opening and once in the closing and then have nobody comment about it or have your themes, the case going totally different from what your initial themes are. That's why it's very important that the witnesses are carrying through witness after witness and that your direct examinations or cross-examinations fit into that. It's also nice if you can take, and we'll talk about this more later, but you can take the backgrounds of the jurors, what their individual narratives are. For example, if you have a failure to diagnose breast cancer case, I don't know, and people on the jury, some of their family members had colon cancer, you can say, well, it's not like colon cancer because this is what's different about it, or something that ties back to something that's in their backgrounds. It's very, very helpful because if you can kind of smatter that around amongst the jurors, then everyone's got a connection to something that you're trying to put into your case, and they have more of a connection to you and more credibility. You'll have more credibility. So you don't want this to happen. This is what you don't want. You don't want everyone to fall asleep. You want them to fall asleep when your adversary's up, right? You want them to pass out. But you don't want this to happen, and that's why a powerful story, you got to keep them on the edge of their seats, okay? And you have to, as much as you possibly can. It's a lot easier, I think, with general personal injury cases or products cases or even other types of PI cases opposed to like a contract, an insurance coverage case or something like that. I don't know if there are any insurance, we do a lot of those also, but they're not barn burners, you know, they're not like people who are really super interested on the edge of their seats. There's more of a story, unless you can develop a story. In antitrust cases in particular, there's a good story. In IP cases, people love inventors. There are ways to get around things, and you know, there are interesting stories. But one of the things that we want to do is, and this is what gets really unique about the process as we go through it, is that if I gave you this and said, hey, here's 2 pages, write your story and your adversary's story in 2 pages. That kind of just sums it up, right? Short. At the end of reading those 2 pages, ask the jurors, what side are you on? I mean, you need to be able to win in that short, like that has to be the basis of your story. And when, in a lot of the research and in cases that we'll talk about a little bit later, in the beginning, our story didn't work. You know, that's the beauty of running different stages of jury research where you can, is that you're refining and constantly refining your story. It's like any other research where you start off and you have a group and a placebo group and you start walking. I mean, the first time out of the gates, no, I haven't found many people that get it like it's all right there. You know, there's refinement. But by the end, and in the case that I'm just thinking of that recently, I mean, we got killed when we first started. Killed, slaughtered. I mean, it wasn't even like, it was just like, whoa, wow, we're in a lot of trouble. And after we kind of like all took a step back and like licked our wounds, then we said, okay, well, what do we got to do? And by the end of this, when we got down to just like a one-page story of each of our stories, rather, we won every single time with like 95% of the jurors, whereas last time it was like we were just getting killed. So there's ways to do it, and what makes the story persuasive? It's simple. I think that's kind of, it's appealing to jurors. It's based on those biases, right? Things that fit into the narrative, things that they find it meets their expectations. That's what I was talking about. Figure out what their expectations are of you, of your client, of the case, what have you. And your story has to meet those expectations, because you're not going to get them to adopt something else. You're going to have to work within the construct or the confines of their belief system, right? Another thing is that it's really got principles that's worth fighting for. If you're on the side of a plaintiff in particular, you know, and you have a plaintiff in a case, you know, it's worth fighting for some kind of a principle in that particular case. And that gets into that reckless, are people reckless, are they not, those types of things. You can use that to your advantage. And one of really the thing I always say is that we really don't want them talking about us. If they're talking about us, there's a problem. We want them talking about them, right? Yeah, your adversary. Everything about them. And that's really, really important. Focus on things so that they're talking about your adversary. So with that, we want to talk about, now we want to walk into the actual science behind it and the brain chemistry behind it. Kelly's going to kind of walk you through that.
Good afternoon, everyone. So before we get into more of the neuroscience background, I just want to go into essentially what's in a story. And I think that this sounds intuitive, but I don't think many people know what story structure is. And simply putting your evidence or a timeline of events as your story, it doesn't function like a story for jurors. They need to see your case in a story format with story structure in order for it to be memorable, in order for it to impact them, in order for them to care about you when they walk into the deliberation room. So the story structure specifically, we're going to start with the exposition, which is they want to know a lot of times, you know, if they're not given the information, they want to know in the deliberation, what is the relationship of these two parties before they came to this dispute? What's the background information? Do they have a good relationship? Do they have, you know, do they know each other or not? All of those things need to be sort of set the stage for the rest of the case. And in this background information relationship sort of part of the story, in your opening, this is where you need to hit them with that broad theme. Here's what the rest of my story is going to be about. Is it about greed? Is it about profits over safety? Is it about personal responsibility? You know, hit them with that main theme, because the rest of the story arc is really going to be setting up the detail with your evidence, with your witnesses, and so forth. So the rising action, after you hit them with that broad scope, with that filter, that they're going to filter the rest of the information that you give them through, you need to talk about the conflict. What were the obstacles of your main character, your client? What was at stake? Okay, right here, we're going to get into a little bit the rising action. That's where you're actually invoking cortisol. Okay, it's that stress hormone that I'm sure that we've all felt at, you know, midnight, whatever, getting ready for the next day. It's pumping through your body. It's you know, helping you meet that deadline. Jurors have the same response that's happening in their body when they hear evidence that provokes this conflict or this motivation to set things right. They're distressed. Hey, that guy never applied his brakes. Hey, that person, you know, they put an unsafe product on the market. It's creating a physiological response in their body that says, when I walk into that deliberation room, I have to set this straight. The climax is really the turning point. So that might be, you know, the accident. That might be, you know, when the inventor, you know, got his invention taken away and someone is off selling his product underneath him. And the following action is really the harm. How is this person's life impacted? You That might be financial, it might be emotional, what have you. And the resolution for these jurors, they're finishing the story. They're ending the story with their verdict. They're gonna determine how this all plays out. So basically, I'm sure that all of you have heard of neuroscience before, but really what we're trying to do as far as incorporating this into jury litigation is understanding how people make decisions, how we form relationships. Basically, how do we think? How do we remember evidence over a long trial, over a short trial? Essentially, how does that, influence our decision processes? So there are a couple different ways that we look at brain activity, and as far as measuring that and correlating that with some of the decision processes that we're looking at in our jurors. The first part might be electrical, which is just an EEG. You might see someone with those electrodes to their scalp and they're measuring that, those responses when they're doing a task. We have the chemical response, which we're going to talk about a little bit later, with the cortisol and the oxytocin. Imaging, which is the new frontier for neurolaw, which is basically looking at people's brain activity, what parts of the brain are active during certain tasks or when they hear a case. So they might hear the plaintiff side, they might hear the defense side, that short one-pager, that short paragraph of the story that Mark was talking about, and they're going to look at basically the brain activity that was happening in that person and how that impacted the decision or the verdict that they came to. So what we know from doing these fMRI studies is that the brain prefers stories, hands down. We give them a list of evidence in chronological order. So-and-so went to the grocery store, so-and-so, got their apples and their oranges and they got into an accident in the parking lot. Brain is flat. When you start to put it into a story format, okay, the brain starts being active in all sorts of different areas. They're engaged, they're listening, they're tuning out up here, they're not listening down here. And at the end of the day, not only is their brain more active, when we give them a test after the scan, we're asking, how much do you remember from the information that we gave you? The people that listen to stories versus just the ones that were read this in a chronological list, remember 65% more information. So not only are you engaging all of these brain areas, and they're actually probably listening to you rather than thinking about what I have to do tomorrow, they're going to remember the pieces of evidence, those crucial points that you need them to remember to fight off the adversarial juror in the deliberation. So what's coming up next is a short video by a neuroscientist named Paul Zach. He has a lab where he's actually looking at how stories impact brain activity and how that actually makes a difference in the behavior of individuals, including jurors, as far as giving money or hypothetical punishment to a criminal.
I want to tell you a story about a little boy named Ben. Ben is 2.5 years old, and Ben has brain cancer. And Ben's really happy. He's happy because he's been through 2 rounds of chemo and radiation, and he feels good for once. He doesn't feel yucky, and his father's enjoying seeing Ben's happiness. But as the father tells the story of Ben and his cancer, the father's voice begins to break. And he says, it's very difficult to play with Ben because Ben thinks everything is wonderful, but I know something that Ben doesn't, that Ben's dying. And he talks about how difficult it is to play with Ben, knowing that in 3 or 6 months, Ben will be dead. And yet Ben is so happy, he's so beautiful. And so the father tries as hard as he can to enjoy Ben, to be joyful around Ben. But then he says in the middle of this short story that it's an amazing thing to know how little time one has left. And as he says that statement, he has merged himself with his son. It's as if the father himself is dying. So in my laboratory, we've studied this story extensively. What we found is that 2 primary emotions were elicited. One is distress, and the other is empathy. At the same time, when we asked people what they felt after the story was over, we really couldn't get very clear answers. So we began doing other studies on this story. So we took blood before and after, and we found that the brain produced two interesting chemicals. One is called cortisol, which focuses our attention on something important. So cortisol correlated with our sense of distress. So the more distress you felt, the more cortisol you released, and the more you paid attention to that stimulus. The second chemical release is called oxytocin, which is associated with care and connection and empathy. And oxytocin was correlated with people's sense of empathy. And the more oxytocin they released, the more empathic they felt towards Ben and his father. Now, we did something different after this experiment. We gave individuals a chance to share money with a stranger in the lab. And indeed, those who produced both cortisol and oxytocin were more likely to donate money generously to a stranger they couldn't see in the lab. In another experiment, we gave individuals a chance to donate money to a charity that works with children who are ill. And indeed, those who released oxytocin and cortisol donated money to this charity. In fact, the amount of oxytocin released predicted in both cases how much money people would share with a stranger or with charity. What we're seeing is that this narrative is changing behavior by changing our brain chemistry. So we decided to go a little further and ask, could we actually predict before they watched the video who would donate money to charity? So with funding from the Defense Advanced Research Projects Agency, DARPA, we reran the study in which we not only took blood, but now we measured heart rate and skin conductance and respiration. And using these additional measures, we were able to identify this distress response and this empathic response, and we could predict with 80% accuracy who would donate money to charity. These individuals get paid about $20 to be in an experiment, and the people who donated money on average donated half their earnings. So we began to investigate this story further. We used functional brain imaging to identify the regions of the brain that were most active while watching that video compared to a control video in which Ben and his father were at the zoo. And what we found was that the most active areas for the emotional story were areas of the brain associated with theory of mind or understanding of what others are doing, and areas that are rich in oxytocin receptors that make us feel empathy. And guess what happens when you watch 100 seconds of a father and son at the zoo? Nothing happens and people just blank out. There's no reason for them to attend to this information because nothing's happening. There's nothing exciting. It's important to understand that stories have to have this particular structure. 150 years ago, a German theorist named Freytag called this the dramatic arc. So there are particular story aspects that go into making an effective story: exposition, rising action, climax, falling action, and then this denouement. The story of Ben and his father talking about knowing his son is dying has those aspects. It captures their attention. There's a coming climax. How can Ben's father actually engage with his son in this wonderful, relaxed, playful way, yet knowing that his son will die soon? It seems like there may be a universal kind of story structure. So stories are powerful because they transport us into other people's worlds, but in doing that, they change the way our brains work and potentially change our brain chemistry. And that's what it means to be a social creature, is to connect to others, to care about others, even complete strangers. And it's so interesting that dramatic stories cause us to do this. In these experiments, they do it in a very functional way. People are donating money because they want to help Ben and his father. And yet when we watch other stories or see movies, listen to music, the same thing can happen. We feel uplifted, we feel motivated, or we feel connected to others around us.
Okay, so before we go on a little bit further, they had talked about some of the brain areas that were associated with oxytocin and cortisol, and essentially the more powerful story that you give someone, the more likely that those brain areas are going to be activated. And in return, what they saw there, the more they activated, the more money people wanted to give to a stranger. So we have a couple key brain areas: the amygdala, which is the emotions processing center of the brain; the frontal cortex, which is important for decision making and judgment; the hippocampus is the memory relay system; and the anterior cingulate cortex as well for decision making and processing. So all of these brain areas need to be activated in your jurors in order for you to walk into the deliberation room with them armed with not only are they care about your case, they have the empathy for your client, they're motivated to defend you in the deliberation room. So you're like, okay, so there's these brain areas, you know, why is that important for me? It's not like I can take a scanner into the voir dire and, you know what these people are. But what we're starting to learn is that the behaviors or the attitudes of certain people actually correlate with certain brain areas. So in this study, which was done in the UK, they had people go into a scanner, and they were doing a gambling task where they were assessing risk before a final outcome. And what they found out is that certain parts of the brain were activated in different individuals. And what they found was that the right amygdala, which is important for flight or fight, or sort of the fear response, was activated in Republicans, and the frontal cortex, the insula, was activated in Democrats, which is more, they find more important for social awareness, fairness, etc. So basically, when you're tailoring the message of your story, right, whether you have, you know, majority of the people on your panel are Republicans, you might think it's more important to adopt a theme or a story that revolves around, you know, threat to oneself and the safety of others, something that really sort of taps into that reptile strategy. Whereas if you have, you know, a whole bunch of Democrats on there, you might think, since they're more concerned with, you know, the intent of others or social awareness, it might be more targeted towards the motive of the parties rather than the reptile strategy. So, you know, learning about these types of things, while, you know, you don't necessarily know what the brain activity is, you can understand how your jurors might perceive some of your themes based on some of this research. So a good story has the power to change brain activity. This is another study where we had a speaker and a listener. And the listener was they were both in a scanner, and they're talking through a microphone. And what they found is that when they used stories, instead of just using just information, like I said, in chronological order, the two brains actually had the same brain activity in the same time frame. It was almost like a mind meld, okay? Whereas if you're just giving information in chronological order, they're not connected in any way, okay? So if you want your jurors to walk in the shoes of your client, you want to engage them, you want them to fight for you, you need to what we call neural coupling, which is, you know, using eye contact, using a powerful story, engaging your jurors so they're not falling asleep like that picture up there, okay? Okay, so Hebb's law, enhanced story memory. We know that neurons that fire together stay together. And something that Mark had talked about, you know, you're not just giving your important theme or your important document one time, you know, in the opening and then one time again in the closing. You're hitting those important themes throughout trial, throughout your presentation. And the more that you show that, the more likely those that message is going to be stronger in the synapses of their brain. So repetition of key ideas is crucial. Also, you want to link it to other cues. Increase the jurors' network. And what I mean by that is by using video, audio, visual, anything that you can incorporate your message into more than one sense is going to help your jurors remember that. So if you're just presenting something to them, they're not going to be as likely to remember 5 days from now. If you also put up a nice picture while you're presenting, you need to show them in a number of different modalities to really solidify that into memory. Mirror neurons, something that Mark had talked a little bit before about, you know, if someone has played tennis or golf their whole life, they have a network set up for that type of activity, whatever it may be, playing the piano, whatever. So even just thinking about it, once you know how to do it, activates those exact same brain areas. Okay, so if you play tennis your whole life just thinking about it, the neurons that actually move your arm are going to be activated, even though you're just sitting there. Okay. So when you're thinking about the ways that you're going to explain something to jurors, the themes that you're going to use, or even particularly the analogies you're going to use when you're talking to jurors, you need to use something that they're going to be familiar with, that they have an experience with, that's going to activate a network that they have in place. So if you're talking to a jury in Iowa, you're not going to talk about hailing a cab in Midtown, okay? Because they don't have that experience, and that analogy isn't going to work for them. And certainly anytime you can get them to visualize the story or visualize the actions of the parties involved, that increases confidence that the story actually happened the way that you said it. So getting them to run through the steps whether it be, through an animation, whether it be a timeline, you need to make sure that they're putting themselves in the shoes and walking through those events as if they're happening. Word selection matters. This is also very important. So when you're talking about, let's say you're talking about an accident, studies have showed that even just word selection can determine the perception that jurors have on the type of accident or the type of damage that was done. So in a study where we used smashed versus collided, the people that read the word smashed viewed the car to be going significantly faster than when we used collided, even though they weren't given any information as such. So they might view an accident as, more catastrophic if you're using certain words. And of course, anytime that you can use some creative wordplay with jurors, that certainly will always spark their attention, re-engage them, wake them up and say, wow, that was really interesting what they just said. Okay, oxytocin, what they had talked about in the video. Certainly, the more oxytocin that you increase, okay, that increases empathy, trust. The more compelling story you tell for your client, the more empathetic, the more trusting that they will see you as well, which is important going into the deliberation. One warning here that they do, the more oxytocin that you create, the less likely they are to remember very specific pieces of evidence. So you've just shown them a picture of this woman and her nice family. Now you're going to show them this, horrible, wrecked car. They're probably not going to remember a lot of specific details right after that, okay? The second that you show them something really emotional, you need to kind of back off the specific evidence. So as something that Mark had talked about, sometimes when you run a case at first, you put everything in a specific order that you think is going to be the most impactful, but it turns out they didn't remember any of that. Sometimes a simple change of ordering information, moving certain parts here and moving pictures here, something that's really impactful, can have a dramatic difference in how they remember that information. Cortisol. So something that people always ask is, what is the best time of day to show my most complex piece of evidence? So something I talked about before, cortisol, it's a distress hormone. It also increases attention and memory. And it actually runs on a circadian rhythm. So it wakes us up in the morning at about 6 to 9 o'clock and says, all right, get up, you're going to work, you gotta be on the ball today. And it starts to come back down around 3 to 6 p.m. when you're getting ready for the evening. So its peak is usually around 9 to 10 a.m. That's when cortisol is at its highest. And certainly that's when attention and memory is also going to be at its peak. So at 3 o'clock, when your jurors are probably stressed and overwhelmed, that's probably not when you want to, throw in the most complex piece of contract litigation or something as well. And not to mention, by the end of the day, jurors are overloaded. There's something called proactive interference theory, which is that the more information you throw at them, by the end of the day, most of it's, falling by the wayside, or it's getting confused and tangled with other pieces of information. So you want to, throw in that best piece of evidence in the morning when they're fresh, when cortisol is running, and they're not probably, hungry and waiting to go home. So like I said, use neural networks, start fresh. Use your most difficult pieces of evidence in the morning. People have limited resources. They can only pay attention and process all of this information for so long. Build on existing networks. Use experiences and experiences that jurors have that they can relate to. Whether it be an analogy you're using, a theme that you're building, you want to use something that they already have a network there for. Repetition. Literally using your themes as often as you can. Reinforcing all of that to build a strong network with your themes. Link modalities. Certainly any way that you can link the cues to your main themes, your key evidence is going to help. Visual, audio, whatever you can use to improve the memory loss. So the trial arc. So really your goal with engaging the jurors with a powerful story is to spark that neurochemical release, which is going to have an effect on their behavior. You want to get the cortisol ramping up, that distress. You want them to feel like they need to walk into the deliberation room with the feeling that they need to set this right for you. You want to enhance neural connections. You want to, like I said, build on existing networks as well, so that they can come into the deliberation room with the memory of the key pieces of evidence for you. Improve memory retention. essentially just give yourself that advantage walking in there that they're armed with the tools to defend off those adversarial jurors. So I think Mark's gonna talk a little bit more about preparing for trial.
Sure. So I want to play you a video, and then I'm going to talk a little bit about how you prepare in a strategy. But I want to move into the voir dire and some techniques there, some of the things that are available. I want to show you just a few graphics that kind of will round things out. Okay, so I talked earlier, this is a juror. She's talking about experience on an actual jury, not in one of the exercises we're running, but when she was on an actual trial for a medical malpractice.
What did you learn from that experience, being a juror?
It was interesting. It was my first and last time. They said a lot of things that none of us understood because it was like the people in this room, we were all from, different areas with different levels of education, different jobs. And the lawyers said things we didn't understand. The doctors said a lot of things we didn't understand. And when it came time for us to be in this little room and talk it all out, we just looked at that, looked at the evidence they had given us and we decided what we thought. And we even discussed the fact that they used terms we had no idea what they were talking about. It didn't make any sense to us at all. It was just kind of silly. If they were trying to impress us, they didn't do it. They did just the opposite.
So she's not talking about just one side. She's talking about both sides in totality, with all the experts, all the doctors. It's not pointed out with both, right? Now the good news is if you're on the plaintiff's side, they awarded $15 million with no understanding of the medicine. So that's your story. If you got a good story, they don't need the medicine, right? Was it the doctor's care? Was it this? Was it that? Things that strike, that what Kelly was talking about, things that are within their belief system that kind of strike a chord, that get them worked up, things like that. But when they're left to their own devices, and they have somebody who's hurt, and their belief that, a lot of jurors believe that cases wouldn't make it to trial if they didn't have some, they shouldn't be here because they would have gotten moved out. You don't know how many times I hear that argument that, well, we wouldn't be here if the judge would have thrown this case out. So obviously it's got some merit. When they were totally lost and they have nothing else, you hear somebody just throw that out, and they'll be like, well, I guess you're right, and then they'll start going, and it's amazing, it's amazing how simplistic it can be because they're all just searching. You heard it. We're all from different backgrounds. We all had different levels of education. We all this, that, and the other thing. That's why also for you guys, as we kind of move into jury selection, be careful about putting someone on your jury, even though you think they're a good juror, but they have some sort of expertise that they could be a leader, leaders and followers. Because if they fall on the wrong side for you, forget about it. I mean, you get one person in there, they could move the whole thing, and people will absolutely defer to them because of what you were saying. We were all from different backgrounds. We didn't understand anything. We didn't know what they were talking about, and I talked earlier, I don't want to feel insecure, I don't want to feel, I don't want to lose footing in the group, I don't want people to think that I'm not smart, I don't want to be disliked, all those different types of things that go on in the room. It's a little different in criminal cases, because when that's on the line, people will go to the wall to be disliked. I mean, otherwise you wouldn't have home juries where you know what I mean? So it's a little bit different, but in civil cases, this is 100% what we see all the time. The other thing is, tort reform has totally worked. So, because I hear all the time about the McDonald's case, and I don't know if anyone's ever seen that documentary, the hot coffee documentary before, so, and knows anything just a little bit about the case, just in general. But you hear that all the time in there, and the other thing you hear is that you guys are getting a third. So that can work two different ways. That can work in the sense that we have to give her more money because we really care about this person, we care about your client, and they say, well, the lawyer's gonna take a third, or it can be, that guy's got no credit, or that gal's got no credibility, I don't trust him or her, because all they want is their third, and they're only in it for the money. So, it just it matters. If everything's going right, and you're, not that you're Vulcan mind meld, but you're neurocoupling with the juror, and you're together, and they're buying the whole story, and it's something that they've got to fix, it's the earlier one, the good one for you guys, which is that, I totally get this, and we've got to add even more on top in order to to get them what they need, but if not, it can work against you. So before I kind of move into to that, I want to just talk about, these are like all the things that we have been talking about to a certain extent. And one of the ones I want to talk about is just if you guys are ever, internally, you should be roundtabling cases with people. I would suggest that you don't use employees from your firm, because if you're there, they want to be employed, so they're not going to tell you something that is bad. They're just not, especially if you're a partner there, they're not going to come and say, you know what, that sucked. That was bad. That didn't make any sense. Okay, go home. Don't come back tomorrow. That's the way that would work. So, it's pretty inexpensive. You can get friends of people in the office, pay them $50 to come in for a couple hours or something like that, throw them in your conference room and do 2 presentations, you and the other lawyer from your firm. If you're the lead on the case, do your adversary side. Don't do your own. You're going to be good enough at doing your own. You do it all the time. It's also a great exercise for you guys to wrap your head really around preparing your adversary's case. And trust me, it works. I get fought on it a lot of times, but once a lawyer does it who I've worked with, they're like, I'm doing that every single time, because I never understood my adversary's case quite the way I did. Because when you're preparing for these, you're really preparing, even if it's just going to be in your conference room. But for these are like getting ready for a little trial, even though they last a day or 2 days or whatever they might be, a half a day. So get some people, pull them into a room, and then walk out and allow somebody else to ask the questions. Don't be a part of that process, because it's also, they're not going to really answer, because you have this authority thing. You just had 2 people that came up and presented to them. If you really want to get honest answers, have somebody else come in, another lawyer potentially, and just ask them, so how do you feel about this? Which side were you on? What were the strengths? What were the weaknesses? These are just some general things. It can be very, very helpful for you, and it's not very expensive, and you can do it right there at your firm. But that's as you start kind of moving up the ladder here, all the way down to different voir dire strategies and shadow juries. Shadow juries are great for openings because of what we were talking about. That early on, they're going to formulate their decisions, and then they're going to be looking for the information throughout the trial to fill that in. So I use shadow juries during openings all the time because I want to know whether we won after the opening. And then if we won, or if we were missing something, or if they said, yes, I'm on your side, but I'm going to be looking for this, then we know we've got to make sure that either they don't find that or we answer that question. And those are the types of things that shadow juries are really great for, just for openings. And they're very inexpensive for an opening, if you have a large case. So voir dire. So let's just talk about voir dire, and then I think we're actually going to be somewhat out of time here. I think that's where I'll kind of take us to, and then we'll move on. So, anybody ever seen Runaway Jury before? Remember back in the late 90s?
Ladies and gentlemen, we are now ready to begin the voir dire.
Miss Coleman. Mrs. Coleman.
Yes.
I see from your questionnaire that you have no particular feeling about guns one way or another. Is that right?
Yes, sir, that's correct. I don't feel one way or another about guns, but I sure hate to see people get hurt, though.
I understand. Do you or your husband own a gun?
Which gun?
Ever fired a gun in sport or in self-defense?
I'll look at the shoulder shrug. Now, she's evaluating the person asking the question before she ever answers. I mean, she's telling Roar exactly what he wants to hear. So you think she's lying?
Not necessarily. She knows how to.
Ricky Coleman, 36 years of age. Her husband's a Baptist minister. She's a card-carrying member of the Sierra Club and a registered Democrat.
I hate Baptists almost as much as I hate Democrats. What else you got?
She had an abortion 2 years ago.
And.
And the guy holding her hand at the clinic? Not the Baptist minister.
Tone of voice, body language, she's got an open mind. I like her. She's gonna be fair and sympathetic to this one.
Okay, so a little bit of unbalance there with, right? So big corporate, maniacal, gun company conglomerate, with all that. I used to make fun of that because that came out, it was 96 or 97, and I used to make fun of it and use it when in CLEs. I've been using it actually in CLEs for that long. I used to say, do you think that stuff really happens? No, that's nonsense. Not anymore. Okay? It's totally changed, and what's at our disposal and what we can do between social media and the internet and everything else. Now, I have never brought a briefcase in with a camera in it and piped it out. That I openly will admit. Everything short of that, though, yeah, we've pretty much done, except for digging through garbage, because you don't have to. The internet's there. There's plenty of garbage on it. You can just get to it very easily with keystrokes in fractions of a second. And you'd be surprised, how much information you can really get on people through the internet, and you can get lists of jurors ahead of time. Like, even if you have 500 of them and you're only going to get a pool of 100, we have these robust reports. During jury selection, I will have 6 or 7 people back here or at my offices, and we are pumping information out of that courtroom, and it's flying back into the courtroom for us when I'm involved in a jury selection for one of my clients. Very similar, to what you're seeing here. So those types of questions, as whether they had a bankruptcy, whether they had a lien, whether they had judgments on their record, whether they visit mortuary sites all the time, even though they don't know the people who died, things like that. I mean, I found all these kinds of things. I found people that wanted to get on a criminal case I was on that involved a drunk driver. A woman had an affiliation with Magna, but never disclosed it during voir dire. She wanted to get onto the jury. We were able to find it. We moved her. The point is, all this stuff and everything that's out there, you want to move as many people for cause, right? I mean, we can all agree on that. Whatever you can get off for cause, you're much better off, both with from a credibility standpoint, from a likability standpoint with your jurors, because you don't want to be moving people or be perceived as the person who doesn't like the jury, right? There's always that aspect. But before we leave, I want to show you something. So this is a products case that I worked on. I use this as an example. I use it when I lecture. I lecture at Seton Hall. I've done at Temple with law students and stuff like that, and just in general. And I always use this as a fact pattern. It's one of the most interesting cases I've ever worked on because of what came out of the case. It's just the way people would take that information, and it's also venue specific. I'll talk about that in a second. So there's this guy, Mr. Smith. Obviously, we cleaned up all the names. So Mr. Smith is a journeyman, but he's an electrician, right? And what we're talking about is we're at a power substation, and the defective product is a voltage regulator. They look like helium tanks. You'll see them on the side of the road at these big sort of power stations, right? Where the electricity kind of comes in and then gets spread out. So what happens is that this substation goes down because of there was bad weather. They had a big storm, and this whole station went down. So they got to bring the station back up online. The issue is that you have to have this thing in neutral. There has to be no power coming in, no positive charge into this voltage regulator. It's like 101. These things have been around for like 30 years, okay? So this guy says, and I'm just going to use you guys as my example. You're my staff for that day. You're my journeyman electricians for the day, and I'm the boss. And what he says to them is, okay, how about you? I need you to go in there, and I want you to reset this thing. I want you to bring it up online. And you tell me to go to hell. Literally, I mean, this is like what's in the deposition. Go to hell. I'm not doing that because you're going to blow yourself up. That's crazy. I say, well, hell, not enough with you. I go to you, and you tell me, no way. I'm not doing that. I come over to you, and you say, no, I'm not doing that. That's literally what's in the depositions. So he says, while another guy's going out to the truck to go get a battery out of his car with jumper cables to try to neutralize this thing, they're going to MacGyver it and do whatever, which would have worked. I decide, well, the hell with all you, I'm going to do it. And you guys run out of the room, go down to and go out of the substation and behind a bunch of trees and literally hide. And what happens? I blow myself up. 85% of my body, I'm burned. Okay? So that fact pattern is not good if you're a plaintiff, right? Would you agree? It's not a very good one, right? Okay. And I ask this question all the time because this would be a voir dire question for the defense. If I was able to prove those facts to you, Mr. and Mrs. members of the jury, would you be able to send this person and their family, their estate, because he lived for a year in a burn unit, which is even worse, and then he died. He succumbed to infections. Okay? One of the worst cases I've ever been involved with from that perspective. And you know what they always say? Yes. They raise their hands, right? How many of you think that you would be able to send somebody home, even though you're plaintiffs? If you heard that, would you think you'd be capable? Maybe not. That's probably not a good question to ask. But if you were a juror who wasn't a plaintiff lawyer, you would think, I probably could do that, right? Well, I'll tell you, when I go through this, they raise their hands. I've had a classroom of, say, like almost 100 students raise their hands until I show them, and I want to show you something. This day in the life video. And I don't want to upset anybody, but The minute that I show this video, it is every single day for a year. Okay? It's brutal, right? Brutal. Okay? I don't even need to show. I don't need to show anymore, but when I go back and I ask that question again, do you know how many people raise their hands and say that they could send them home with nothing? Out of the 100, probably about 4. Okay? The point is that a picture and what we're talking about here changes everything for people. Okay? And if you're on that side, if you're in there and we went in and we played this, I was on the defense in this case, we played this, I moved 75 people with the lawyers, we moved them all out for cause. We moved people, just endless amounts of people by just playing. When I tell them, when you just say it, and I say, I gave you the story, I mean, I tried to told you all everything I could tell you, and it's not as effective. So you're able to do that, so you would want to fight like hell to not have something like this played or a picture or something like that. You don't want to have that played. I mean, I think that's pretty obvious, but it has that much of an effect on people, and the same way like with children, bringing in children that are on respirators or things like that. You really want to, people think they can do it and they can't. And if you want to use that to your advantage, if I'm on the plaintiff side with somebody, the first thing I want to do is I don't want to expose them to that much. I want to kind of get them through, let them think that they can do it. But if you're on the defense side and the defense wants to do this, it's very effective and they do it all the time. So I don't want to end on such a gruesome day in your life, but there's more food back there.